Good evening, everybody. Omar Serrato with the Tilted Lawyer podcast, and we're going to dive a little deeper into this 47.1, CCP 47.1 that Blake Lively has raised in her motion to dismiss. Earlier this morning, I kind of took a different approach. I know that most folks read that motion. The Two Lawyers podcast, I forget what they call themselves, the Two Lawyers or whatever. People were freaked out because they're saying, hey, it seems like they're trying to say that Justin Baldoni's countersuit against Blake Lively is going to dismiss. And I just don't see it that way. I don't see it that way. I think you have to look at it like this. Number one, there was a clear and a concise legislative intent to that statute. And because it's so new, it has not been tested in the arena of federal court very often, as it appears that it's going to be tested in these arenas. In other words, there was a method to whatever it was that California did. And we're going to go over some of the legislative intent. One of the really excellent questions that I got about it, I'm going to share with you guys. I just screwed this up. But I'm going to share this with you guys because I thought that it was a really good question that deserved my attention. So this was the question. I have yet to see a lawyer address the requirements of 47.1 that state that communications must also, in addition to without malice, be factual and meet the definition of SH, which includes pervasive and severe. It seemed to me that the Two Lawyers podcast guys came across as very biased against this law and jumped on what they saw as an opportunity to validate why claiming that the law could be exploited in this way. I see the intention behind 47.1 being to deter defamation suits being filed as a way to intimidate or retaliate against someone making allegations of SH. But Baldoni isn't using the defamation suit in that way. He filed because they genuinely believe that they think that they can prove he has been defamed. He wouldn't have filed if he thought that he couldn't win against her accusation of SH, in which 47.1 wouldn't apply to her anyway. To that assumption, not every lawsuit is filed because you think you can win. That's just rule number one. That's a naive way of looking at civil lawsuits in California, let alone the United States. But I'll tell you what, she continues, in my opinion, it just looks like Blake Lively's team is trying to intimidate Baldoni into backing down by even bringing 47.1 into it. The only way it would actually apply in this case would be if her allegations were true and the definition and without malice, which is clearly not the case. But that would be for a jury to decide. That it would be for a jury to decide is exactly right, which is kind of the point, which is why I don't think that this lawsuit is getting dismissed, because it is a triable issue whether or not there was a finding of malice. It is a triable issue whether or not Blake Lively knew knowingly that she was making false allegations against Justin Baldoni for malicious intent. Let me share with you guys kind of the spirit of what 47.1 is. So I'm taking this straight out of my legal research. This kind of breaks down exactly what. It kind of answers your question. California Code of Civil Procedure, Section 47.1, provides a privilege for communications made by individuals regarding incidents of sexual assault, harassment, discrimination, providing certain conditions are met. Specifically, the communication must be made without malice, obviously. It must be factual. So that means you kind of have two bites at the apple. If. Now look, I'm going to be tempted to go into the case against Ryan Reynolds because I think it's an easier case to prove. But what Lively's going to assert is that, look, I had a whole list of grievances for this guy's shitty behavior. I put it in a list. We all talked about it. You guys said, you know what? I understand, Miss Lively. We're going to accommodate you. And that to me was an admission that you guys knew what I was talking about. I let you guys know back then. I published these thoughts way back in 2023, and you guys wanted to continue on with the production of this film. And so don't tell me that you guys didn't know what was going on, because do not begin to try to tell me that my allegations were not truthful, because not only were they truthful, but I put it in a list. We all sat in a circle and everybody talked about it, and everybody agreed that we were going to change certain behaviors, and we continue production on the movie and so forth and so on, whatever. That's what she's going to argue, obviously. What Justin is going to argue is that, look, I had no way of knowing whether or not she was being serious or not. It seemed to me that she was making complaints just for the sake of making complaints. We had a lot of money invested in this movie. We had to get things going. We were on the hook. We were losing money every single day the longer that this dragged on. She kept on making all of these demands, all of these changes. It was putting us behind. It was way too far in the production process to try to change actors now. It would have been a multi-million-dollar disaster. We had no choice but to acquiesce to her demands, because we knew it was the only way that she's going to continue production. We didn't at that time attribute that list to confirmed sexual harassment, because everybody on the set knew what was going on. Everybody on the set was aware of what Baldoni was going through. Everybody on the set was aware that Blake Lively was being difficult and breaching contracts and breaking agreements and breaking promises and making demands. And the only way we were going to finish this movie was if we were to say, you know what, I see your list. I'll tell you what, we'll do better in the future. I'll tell you what, we will do whatever accommodations you want. We will make sure that they are met. That is not the same thing as claiming or making the argument that that list and their acquiescence to that list was an admission that the behavior on set was anything less than standard for a movie that involved the things that it involved, including intimacy coordinators and nudity writers and nude scenes and scenes depicting live births and wearing onesie pajamas and the like. Those are the competing arguments. Could you find any clarity in those competing positions? Because I promise you, do not freak out at this 47-1 nonsense. It is a well-written motion. I'm not going to read it word for word. I'm not going to do that. I understand why you would read it and say, oh, holy shit. Not only did she publish this and everybody just kind of agreed, but it was back in 2023. And we've all agreed that California is going to be the law that applies under this jurisdiction, under these contracts. And there appears that we might have a statute of limitations problem. My dog is barking, folks. Let me go let my dog in real quick. I'll be right back. My dog is over there carrying on like that. I should probably make sure there ain't nothing strange going on in the comments. Yeah, it looks like everything's okay. All right, so I completely lost the tenor of what I was saying, but all I'm saying is this 47-1 is not the protection that Blake Lively and her attorneys thinks it's going to be. If they thought, look, you have to know that when I'm just basically approaching this case the same way that I would approach it if it was my own case, I would see something like 47.1. Okay, problematic. But what is the heart of our argument? The heart of our argument is that this is a big conspiracy, right? I know it's one thing to say conspiracy. It's quite another to prove it. But here's what I know. I know that Blake Lively and Ryan Reynolds appear to have been in cahoots to try to smear my client's name. And how did they do that? Ryan Reynolds was running around to potential future employers talking about he's a sexual predator. Blake Lively was trying to stretch these bizarre claims for the entirety of the production that nobody else saw, but she was very concerned with, and threatening to halt production unless certain accommodations were made. That doesn't appear to be in good faith, but we had to get it done. My client had to get it done because he was going to lose millions of dollars otherwise. His reputation might have been shot. We had known, and he had suspected all along, that she was going to try to public. It's one thing to publish defamatory statements amongst your friends where nobody believes what Blake Lively is saying and everybody's kind of on your side, which appears to be what was going on the production of the sets. Blake Lively made herself out to be this prima donna, total, just trying to take control of every little thing, was on every single person's nerves in the production of that film. And all of them was ready for Lively to try to go run to the press to spout off whatever nonsense she was trying to spout off during the production of the film. Now, they internalized it. They recognized it. They probably investigated and said that, you know what, there's nothing really going on here. But we got to finish this movie. We have to finish this movie. That is not defamation with malice just yet. Right now, all we have is difficult actress. And tell me that Hollywood doesn't know how to deal with difficult actresses. But there was always the wild card, which is, but what if she tries to go to the press and destroy the character of Justin Baldoni because of, I don't know, she thinks that it's not going her way in social media? Because organic social media posts seem to be riding this wave that Blake Lively is turning into this mean girl, bullyish type, akin to what her husband was doing, the whole nice pull thing, the whole bit, all of it. That was all organically grown. That's what Jed Wallace is going to say. So yeah, we brought, yes, a PR team was hired, and yes, I was brought in to observe and give my and give a consultation as to what I thought would remedy this case and what I thought we should do after surveying the entire landscape, after talking to hundreds of people that were familiar with the situation, after reading the tea leaves of how public relations was going, was I thought that we should do absolutely nothing. Blake Lively was falling flat on her face. We simply didn't have to worry about it. She was taking care of it herself. And because of that backlash that she saw, all of a sudden it's Justin Baldoni has hired a PR team to smear Blake Lively's good name for financial gain with malicious intent and all the rest of it. No, they were ready for that. And the second that they caught wind that she was going to start leaking to the public that these claims of, that were internal at one point in time were now going to be leaked to the general public, where the media was going to start running with claims that, hey, Blake Lively is saying that Justin Baldoni is a sexual predator. It's starting to get out that she's having issues with Ryan Reynolds on the set of this film because of his predatory behavior. What do you think of that? Should he be canceled? And you know how that goes in Hollywood. And so you have this entire wave of everything that's happening. And it's not readily apparent in the moment back in 2023 that she has any malicious intent. She might just be some crazy over-the-top actress with a list of demands that's difficult to work with. There's been hundreds, if not thousands, that have come before her, and there will be hundreds and thousands that come after her. That's not really all that much to write home about, is it, in Hollywood on the production of a film? So back to this 47.1, so we could understand what we're dealing with here. Communication must be made without malice. It must be factual. The factual part of it is kind of telling. Now, look, there's actually 3 issues with her SH complaints. The first one is the complaints are ridiculous. Would a reasonable person, on the basis of the 6 claims that she made, constituted sexual harassment. And I will read them again. For everybody in the back, she listed the following as incidents that occurred that amounted to SH. She says, after the first day, Mr. Baldoni enters Mr. Lively's trailer to voice his concerns that Miss Lively looked unflattering in publicly released photographs. During the meeting, Mr. Baldoni became emotional and told Miss Lively that he thought her appearance was failing to meet audience expectations. That's totally sexual harassment. That's totally sexual harassment. Is it sexual harassment, or is it telling her to get her shit together? And look, he's not her husband. He doesn't have to be nice about it. That, if he were to call that anything, if he were to call it something nefarious, it would amount to maybe a mean comment, a crass comment to a coworker. But they were aligned in one goal. They had to project an image. It was well known that they were in production of the film. They were supposed to be giving interviews and be talking about and advertising campaigns and building up this movie. It behooved her to run a comb through her hair if she were to step out, and I don't even know what they're talking about. I'm just talking shit at this point. I'm just saying that's example number one. Would a reasonable person liken that to sexual harassment? That's a claim, but that is an argument based on the merits. Is it even true? Because if it's not true, then it's not protected under 47.1, is it? Now, this statement alone is not an allegation that I don't think that you could argue is malicious in nature, but taken in concert and in series with each other, what you have is a pattern of untrue claims alleging sexual misconduct for malicious purposes. That's not the kind of allegations that are protected under 47.1. So let's not be too hasty when we start declaring that Justin Baldoni's countersuit is going to get dismissed on account of 47.1. That is not what I see. I don't see that. I don't see that. And I expect Friedman and his team to argue in full force something similar to what I've just stated. They'll probably do it a lot better than I. Instance number 2. At some point in May or June of 2023, a simulated noon scene was filmed without an intimacy coordinator present. And if I was giving opening statements, and the evidence will show that Justin Baldoni and Blake Lively had sat with members of the production team, had carefully crafted that you will see exhibited by handwritten notes about what would go into these intimacy scenes and what would constitute provisions on the nudity writers. And they spent days crafting out how specifically everybody's going to be protected. And in the moment, and when the time came, Blake Lively told that intimacy coordinator that she wasn't needed and she could take her coordination and shove it up her ass. She waived the intimacy coordinator because she didn't think that she needed it. And then she turns around and alleges Justin Baldoni of SH as a result of her waiver. That is malicious, knowingly false allegation that is not protected under 47.1. Allegation number 3. Mr. Baldoni discussed orgasming while having sex with his wife, remarking that those have been some of the most beautiful moments between them. And yet, ladies and gentlemen of the jury, the evidence will show that Blake Lively and Justin Baldoni had formed a very close friendship in the months leading up to the production of the film. They took pictures with each other's children. They took pictures together. They texted each other back and forth day and night, talking about all kinds of very intimate details of their life that were not sexual in nature, but some of them that were sexual in nature. And the evidence will show that there was an occasion where it appeared that Blake Lively made an innuendo that she was the type of person that knew how to give a blowjob without using her teeth. And then she turns around and wants to throw this back in Justin Baldoni's face and claim sexual harassment. That is malicious in nature because she knows good and well that it was false. She knew good and well that it was within the boundaries of their relationship at the time, and it is not protected under 47.1. Point number 4. Mr. Baldoni asked Mr. Heath to show Miss Lively while she was eating lunch a video of Mr. Heath's wife giving birth at home, part of which Mr. Heath subsequently showed her. Now, you guys have all seen the screenshot of what that was. Heath and his wife in a bathtub and the afterbirth. Granted, even if that's gross, does it amount to sexual harassment? Does it? To a reasonable person. And I've polled lots of people. I've polled lots of you with respect to this question. And then the very best that I could come up with was, I mean, it's kind of gross when you're sitting there trying to have your ham and cheese sandwich. But sexual harassment, not so much. Not so much. Point number 5. Mr. Baldoni improvised while filming romantic scenes, which was consistent with his prior experience of rehearsing or filming scenes multiple times, often with variations without needing permission. But the evidence is also going to show that these rehearsals were filmed, and Lively is on film, showing no measure of discomfort. Matter of fact, there was a playful back and forth. They were kind of doing it together. And she was so threatened and so uncomfortable that she decided that she didn't need an intimacy coordinator for the filming of those scenes. That's another one. That's 5. 6, Mr. Heath was present in Miss Lively's hair and makeup trailer at her invitation, by the way, while she had body makeup removed, and despite her asking him to turn away while they spoke, he may have made eye contact with her at one point and later apologized after Miss Lively told him that it made her feel uncomfortable. He apologized. I'm sorry, I accidentally looked in your eyes when you had a breast pump going. You're the one that told me to come in. The evidence is going to show that Blake Lively invited everybody into her trailer as she was in various stages of undress, as she was pumping milk, and then later claims upon somebody accidentally making eye contact during the occasion that it was sexual harassment, not even at Justin Baldoni, at Mr. Heath. There was when Mr. Baldoni hired a friend to play an obstetrician in a scene in which Miss Lively's character gives birth and in which he would be in close proximity to her genitalia. I mean, somebody was going to be in close proximity to her genitalia. It was a live birth scene. Sexual harassment, though? Mr. Baldoni used the word sexy to describe Miss Lively at least 2 times, including when Miss Lively was wearing a onesie with a big coat, probably in a joking manner, because I'm sure that she looked very sexy in her Tickle Me Elmo onesie or whatever it was. And they joked around like that all the time. There was no indication on the part of Justin that he should have known that that was out of bounds at the time that he made that comment. So we have that. 47.1 is meant to protect truthful, good faith, non-malicious claims of sexual harassment. It was written with the best of intentions. And what Blake Lively's lawyers are attempting to do is pervert this statute and use it as an affirmative defense against Blake Lively's clear and unabashed maliciousness towards Justin Baldoni, in concert with shielding her from conspiracy theories where she actively engaged in a conspiracy to wrestle financial and creative control over the film and ruin Justin Baldoni because her husband was jealous of him. That's not the kind of thing that is protected under 47.1. And it will never be the kind of thing that's protected under 47.1. This law is like less than 2 years old. It actually might be exactly 2 years old or a little bit over. It came about in 2023. I'm going on my rants, and I haven't even gotten through some of this stuff. This privilege, did I get to this part? Must be factual, must relate to incidents that meet the legal definitions of harassment, including being pervasive and severe. Pervasive and severe is problematic, isn't it? I mean, if you cannot meet the per se And look, there's been a lot of discussion. Why aren't they trying to dismiss Lively's claims? And they can. I feel like they can. They can make some of the same arguments. Those are the those are the 7 instances that you're talking about. I don't think that fits the language of pervasive and severe. I don't think they've even made a per se showing that SH is a thing. Maybe they have, I don't know. But to have it protected under 47.1, no, that's not what's going on here. We're not doing that here. We're not doing that today. This privilege is designed to protect individuals who have a reasonable basis to file a complaint, even if the complaint is not formally filed. The statute also provides remedies for defendants in defamation actions, including attorney fees, treble damages, punitive damages if they succeed, defend against claims, blah, blah, blah stuff. To qualify as privileged under 47.1, communications about sexual harassment or sexual assault, harassment, discrimination, incident privilege, the communication must meet the following requirements. Must be made without malice, meaning it is not made with intent to harm or with reckless disregard for the truth. It must be based on factual information related to incidents of sexual assault, harassment, or discrimination, and the incidents must meet the legal definition of sexual harassment. Pervasive and severe. For example, under 51.9, sexual harassment includes unwelcome sexual advances or conduct of sexual nature that's pervert. I think you guys get the point. That is what it's supposed to. It protects specific allegations that meet the legal definition, that are clearly not malicious, and that are good faith, that are made in good faith, meaning we think that they're true. So there's that. So what then about how the law has treated some of these cases? Let's talk about that. So I did some digging. I did some research. And I found some cases. And let me pull some of these up. Okay. So I know that this law is very new. But there are some cases that have dealt with 47.1 that I thought might apply to this case. There's a case called Doe v. Leader. It's not a federal case. It's California court. It's a California state case, but it deals specifically with 47.1, and it's going to give this court direction on how to handle this case. So it's a recently published case. It involves an ex-girlfriend and her friends who launched what the court had described as a vengeful smear campaign to harass and defame the plaintiff after high school. Let me see if I could pull this case up for you guys. Yes, this is the case. Let me share my screen with you folks. You can see what I'm looking at. No. Oh, where'd it go? Window. Oh, it came up as a PDF. Well, that's not helpful. Anyway, this is the case. This is the case that we're talking about. So it involves ex-girlfriend, her friends. They launched what the court had described as a vengeful smear campaign to harass and defame the plaintiff after high school. The defendant emails the plaintiff's college. It was Dartmouth College. They accused him of misconduct. Voter fraud was a thing. They sent him messages. They sent messages urging others to avoid him because of men like him think that it's okay to disrespect women and be violent. In other words, they were picking on him for whatever reason. They just wanted him out of the picture. And so they're telling everybody there was some kind of a vote that would happen, that he needs to be avoided because of men like him. They think that it's okay to disrespect women and be violent. Sort of like what Blake Lively is attempting to do with Justin Baldoni right now. Does this sound familiar? So Dartmouth revoked the plaintiff's admission as a result. The defendants moved to strike under the anti-SLAPP law in that state, arguing that their statements were protected activity. The court denies protection, finding that communications were not legitimately aimed at any proceeding or public issue. They were retaliatory, personal attacks. It illustrates that if you can prove that there was a coordinated, malicious defamation campaign that was disguised as a harassment report, that it is not going to be shielded by privilege under 47.1 or otherwise. There's another case. Now, this case was before 47.1's time, but I think it's instructive. And you got to understand that 47.1, there's not a lot of cases that deal with this statute specifically. Matter of fact, the case that we even had just discussed, I don't think that 47.1 was even a thing, but they blatantly stated, you know, the way that these cases have been treated is that if your SH complaints are not made in good faith, then you're not going to have the same kinds of protections that some others would have. 47.1, keep in mind, our North Star when it comes to whether or not you're protected under 47.1 is it truthful? And if it's not truthful, did you think that it was truthful? Do you believe that it's truthful? Like genuinely, in good faith. Number 3, do you have some kind of malicious intent? Do you have motive to get rid of this guy? Like in this Dartmouth case, I guess they were running for competing offices or something. There was a reason why they wanted him out of there. In Lively's case, there's a reason why they wanted Justin out of there, because they wanted to wrestle creative control away from him to control the film. They wanted to strip him of film credits and add to their own. They wanted to strip him of his image and add to their own. For why? Well, it's complicated. We're going to have to get to the bottom of that at trial. But, I have a feeling that Friedman is going to start connecting these dots. And look, I don't want to mislead you guys, because Justin Baldoni's First Amendment complaint is probably going to need another amendment, because he doesn't outright really plead maliciousness in his complaint. He doesn't. It's not really in there. Not enough. Now, granted, we're stating and we're claiming and we're believing, and I'm assuming that in the course of discovery, that some of the holes in this case are going to be pled or discovered, and that there's going to be an amended complaint where some of the holes in this First Amendment complaint are filled. I have to assume that, because if not, then the complaint 100% is in trouble. In other words, you guys have heard me make a very impassioned argument and plea for Justin Baldoni to overcome this motion to dismiss. But that's just me talking shit. If they don't actually believe in that argument, and they're not going to make that argument, they have to argue something else. I don't know what they're going to argue. What I've argued to you is my interpretation of the facts and how I would attack it if I were in Friedman's shoes. But Friedman is a much better litigator than I. He might have something better up his sleeve. At every stage of this litigation, he's been genius level smart. And so I have no doubt that he's going to be able to maneuver this 47.1 issue. I'm just not as worried about it as the two lawyers show, or whatever it's called, as they were initially. And granted, I don't think that they never said, they did not say that Lively, or maybe they did, I didn't watch the entire thing, but it just seemed to me like they were saying that even if this 47.1 works, Lively's still going to have to answer for some of the other stuff, because he's going to be able to put on a vigorous defense. That was my takeaway from the part that I watched of their show. But I don't recall them ever saying that, oh, definitely Blake Lively's going to win. I don't recall them saying that. I don't think, hearing them analyze and break down cases, that they would say such a thing. But maybe I'm wrong. I've been wrong before. So there's this other case where how they found malice. So this is a case, it's called Shep versus Capital One. It's a 2017 California case. It arises in a different context of this Lively case, but Shep is frequently cited for the definition of malice in California defamation law. So we have to figure out what malice is, right? And this is kind of helping us define it. So the Court of Appeals reaffirms that under Civil Code 47, which is the common interest privilege, a statement loses its, this isn't 47.1, don't get that confused. It says 47, it's a different privilege. But a statement loses its privilege if made with malice. And that's repeated in 47.1 is kind of my point. Defined as a publication motivated by hatred or ill will or made without reasonable grounds for believing it is true. Reckless disregard. This is nothing new. We're not breaking any ground here. In that case, an employer's statements about an ex-employee were protected absent malice because the plaintiff could not prove that the statements were knowingly false or driven by ill will, so the privilege held. In other words, that's a problem for Justin Baldoni. It's a problem if you can't prove that it's not the end of the world, but it is a problem if you can't prove that Blake Lively, in her 17-point list, that all of those statements that she knew were fundamentally false. Because I think that the narrative going back to the very beginning was, I think that she really believes what she's saying. There was even text messages back and forth. The motion to dismiss made a mention of it, which is like, oh my God, they did say that she thought that she believed the statements. So we can't argue now reckless disregard. Sort of. But what if, and just hear me out, what if she knows that they are, what if it's not the fact that she doesn't think that they're true? What if it's the fact that she knows that they're not sexual harassment per se? In other words, what if her conduct before the falling out was such that it would appear to a reasonable person that those 8 instances or whatever it is that we went over in her motion would not have, under normal circumstances, in the context of their relationship, amounted to sexual harassment. And then she just flips. And it's the changing of the rule book that is knowingly reckless. It's the knowing that she played by one set of rules before and then unceremoniously flipped the rules, where it's like, you know what? Don't talk about you and your wife's orgasms. I don't want you coming to my trailer making eye contact with me. I don't want you hiring your friends to get close to my genitals in a live birth scene, which are these ridiculously asinine allegations that she is wholeheartedly believing amounts of sexual harassment. Now they start to believe it because she's acting crazy. But what if the reckless disregard for the truth is the fact that she changed the context of their relationship without telling anybody else? And she did so recklessly, and she did so that she can argue that she was truthfully believing that these allegations amounted to sexual harassment, and she did it with malicious intent. Now, I don't think you're protected under 47.1 anymore. Now, look, am I taking liberties with these facts? Look, I'm spitballing. I'm talking this out. It's the same way that I would talk it out in my office with my legal assistant, with my colleagues, with whatever. I'm arguing with you folks. Like, what does reckless disregard actually mean? Take those incidents all together and you look at them individually. Each one of those things individually is not sexual harassment. I don't care who you are. Now, you have 8 of those in a row. Individually, they're not sexual harassment. But now we've created like this. She is claiming that these 8 instances amount to an unworkable work environment where she needs to pause production to address her concerns. What changed? Because it seemed like everybody was getting along just fine. And then continuing under that first set of rules, now she's got issues. Something changed, and it wasn't her discomfort with Justin Baldoni. It was her discomfort with Ryan Reynolds. It was her discomfort with Justin Baldoni's rejection over her stupid flirtatious attempts through text message. I am wildly speculating and making arguments, but I really think that they fit. I would walk into court and argue those, and I think that a jury may find some merit in that argument. I really do. So this case, and Chef, an employer's statements about an ex-employee were protected without malice. The plaintiff could not prove statements were knowingly false or driven by ill will, so the privilege holds. This case underscores that even communications that are ostensibly protected, such as workplace misconduct reports, such as running to the HR department on the set of the movie, receive no immunity if the speaker had a malicious state of mind. And there is not a chance in hell that you can convince me that this judge is going to say that, yeah, there's no evidence of malice here, without at the very least giving Justin Baldoni the opportunity to amend his complaints. And I think that the argument's going to be, as I stated earlier, that, look, we didn't know at the time that she was going to run with this as like a legit sexual harassment claim. We were just trying to keep it under wraps because we were just trying to get through a film. But then we were tipped off that she's going to start leaking stuff to the press because she's actually escalating this. First it was, we're changing the rules. Then it's, we're making your role less. Then it's, we're stripping him of credits. Then it's, we don't want him involved in the post-production at all. And then it's, you know what, he's a sexual predator. And that escalation is what drove us to believe that now she has a malicious intent, which, by the way, that should be when the statute tolls, not from the date that she published those 17 point whatever it was back in 2023. All right. There's another case. McGrory versus Applied Signal Tech. That's a CalCourt App 2013. It was a legitimate harassment investigation versus pretextual attacks. The case involves an internal sexual harassment investigation and subsequent defamation claims by the accused employee. The court holds that statements made during a workplace investigation into misconduct were protected by the common interest privilege. This California, that's CCP 47. Because they're part of legitimate process and no malice was shown. The investigators reasonably believe the allegations, blah, blah, blah. So notably, the court emphasizes that if the plaintiff had raised triable evidence, this is key. The court says that if the plaintiff had raised, the plaintiff being the person claiming defamation, triable evidence that the harassment accusations were false and driven by animus or a predetermined plan to oust him, then the result may have differed. And what do we have? We have allegations that Baldoni is claiming are driven by animus, a predetermined plan to oust him, and he was ousted. With malicious intent, that is not going to be covered under 47.1 if the judge thinks that it is a triable issue. Again, this is not going to be a granting of the motion to dismiss. This is at best going to be a leave to amend. We will grant you 90 days to amend your complaint. They did not stay discovery for Miss Lively, which means they've allowed the investigation to continue. I could see them giving them 120 days to complete discovery and fill in the gaps. I can see that. I can see it. There's a Williams versus Taylor. That was a false harassment allegation of defamation. So it was a 1982 case going all the way back to 1982. It was CalCourt App 1982, if you wanted to look it up. Williams versus Taylor, but it's an early defamation case where an employee's false accusation of sexual harassment against a coworker was held potentially actionable as defamation, potentially actionable, despite the context of a workplace complaint. So the court recognized that a baseless claim that someone engaged in sexual harassment is defamatory per se, and it suggested that no privilege protects knowingly false accusations made with malice. So I don't think that I'm really breaking any new ground. I think you guys already know this already. My only point in going through these cases is to let you guys know that, look, historically, malice is not all that hard to prove, at least for the context of making it actionable. Meaning if there's at least a per se case alleged of malice, and I think that they're going to get to amend their complaint to show that, then they get to proceed on their defamation claim. That's it. If you can't do it, then you can't do it. But if you can, it's going to trial. That is all. Motion to dismiss denied. We're going to effing trial. That is all. That is all. Privilege historically in California has been under CCP 47. Now we got 47.1, which extends it. I don't think that it's going to be treated any differently than 47 with respect to what is protected through privilege and what isn't. We're just not. I found another unpublished case, but I'm not going to go through it. I wanted to talk a little bit about tolling the defamation statute. I think that that's going to be instructive. So the way that tolling the statute works is that if there's a statute of limitations, let's say that you have, okay, the statute of limitations for a defamation case in California is a year. Fine. But what if you don't learn about the harm until like 16 years later? Then reasonably, the statute of limitation does not run, it doesn't begin until the date that you learn about the harm. So they're going to claim that, look, Baldoni knew about these defamatory statements all the way back in, what do they say, December of 2023 or whatever it was. Back in 2023, he should have known. Not only was he aware of what we were alleging, that there was a whole meeting about it, and he agreed that she believed what she said and that he was going to change his behavior. That's the argument. But then there's my argument that I think that they're going to make, which is we had no effing idea that this was going to rise to the level of malicious defamation. We know the effing law about 47.1. We're not trying to chill the speech of prospective victims of sexual harassment. As petty as these claims were, we weren't labeling it defamation then. We didn't label it as malicious defamation until the date that it became readily apparent to us that she was trying to ace Baldoni out of Hollywood. We didn't know about that. We didn't genuinely have any idea that that was going to be a thing until around August. And this complaint was filed like 5-6 months after that. So we're well within the statute of limitations. Anyway, that's how it applies in this case, but this is how it works in other cases. So in Manguso versus Oceanside Unified School District, it's a 1979 case. It's California Court App 1979 if you wanted to look it up. But in Manguso, a school principal placed a derogatory letter in a teacher's confidential personnel file. The teacher did not learn of the defamatory letter until 16 years later. This is obviously an easy case, right? When it was shown to prospective employers. And she's like, what the fuck? The Court of Appeals applied the delayed discovery rule, holding that defamation cause of action accrued when the plaintiff discovered or reasonably should have discovered the libel, not when the letter was initially filed. The court reasoned that statute of limitations should not bar a plaintiff before she could reasonably be expected to discover the defamatory statement's existence. And in this case, I'm not even sure if the statute should run at the time of the defamatory statement was made, or if it should run at the time of the discovery of the malicious intent, because I think you need both. If you have one but not the other, I don't believe that the statute should run until you reasonably have both elements: a knowingly defamatory statement that is malicious in nature. You got both of those. I don't think Justin had that until like August. And, maybe it was a little bit earlier, maybe a little bit later, but there was definitely a plan. It just feels like this lady is a bit much, and everybody's talking about it. There's all these murmurs about it, but then it's like, you know what? Let's just get this effing movie done. We got to get this movie done. It is what it is. We're already here. We're already millions of dollars in investment. Let's just get it done. And then it's like, oh, well, shit, she's going to start leaking sexual predator comments to the press. I think we need to take action. That's where we're going with this. So that's the Manguso case. Here's another case about how it works. And Bernson versus Browning Ferris Industries. It's a California Supreme Court case from 1994. It was about concealing the identity of a defamer. It stops the limitations defense. So Bernson involved an anonymously circulated defamatory dossier that targeted an LA City Councilman, Bernson. I'm getting this right off of the stanford.edu website. I apologize. I have not been sharing my screen with you guys, but if you guys wanted to look it up, this is where I got the case. I mean, hell, I ain't shared all the rest of them. I might as well share this one. All right. So this is the case that we're talking about. If you wanted to look that up, these are the facts. This is all of it. I'm not going to read it word for word, obviously, but this is the case that I'm talking about. You're going to have to just kind of, I'm going to summarize it for you guys, but basically this was a case where Bernson, he's this LA City Councilman. He knew about the smear pamphlets in 1988, but he didn't know who was responsible for the pamphlet. The culprits concealed their involvement in the creation of the document. He discovers the identity only years later. And so the California Supreme Court then holds that equitable estoppel can toll the limitations period when defendants fraudulently conceal their identity for role in the defamation such that the plaintiff, despite diligent efforts, could not earlier discover whom to sue. In such cases, a defendant may be stopped from asserting the statute of limitations as a defense. In other words, if you actively conceal that you're the one that did something, you don't get to claim statute of limitations when they barely learned about it like a couple of months ago. Fuck off with all of that. And so I think you guys kind of get the gist. You get the gist with that. And so, look, I've been going for 52 minutes about this. Jackie Graham says, isn't it time to introduce better laws to protect people from false accusations? Yeah, I think as wacky as California is as a state, I will say this, at the very least, they recognize that there is a really good percentage of instances where defamatory claims of sexual harassment do include malicious intent. I was being sexually harassed because they're trying to get the big promotion. I'm being sexually harassed and they're trying to get their, for DV purposes, their husband out of the house because they want to move in somebody else or whatever. They want to get full control of the children or whatnot. It's not limited to Hollywood. I mean, it affects all aspects of life. It's always been a thing in California, as absurd as 47.1 appears to be. It is well grounded in this principle that, look, we're not going to protect your malicious intents. And I think that where we're going with this, and I think the way that this case is going to evolve this particular statute is essentially this. If you have defamatory statements that are made in good faith, that's one thing. But upon discovery of the malicious intent that happens sometime after the defamatory statements, as we've seen in some of these other cases, you don't get to claim statute of limitations for that. And you know what's more? Because of the malicious intent that's now been discovered, that is now a triable issue, you don't get to hide behind 47.1. You can fuck off with all of that. I do have super chats, Angel. Yes, I do. The cat lady with 5 says, I just learned that Blake's contract was under an LLC, which means she was never an employee of Wayfair. She was only a contractor. It doesn't well, I don't mean to curse at you, cat lady. It doesn't matter. It doesn't matter. It doesn't matter because regardless of whether or not she was an employee, regardless of whether or not she was a contractor, SAG has certain rules on how to deal with that. I understand that she didn't sign her employment contracts. I understand that a lot of people think that because of that, she's not bound by the terms. But the reality is that she was presented and negotiated terms of a contract that were placed in writing. And because of those negotiations and because of those writings, she showed up on the set and set out to make a movie. And they did make a movie. And she was paid for it. And so even though it was not bound in writing, they bounded together in contract through their actions. Written contracts are not the only ways to bind people to promises. Verbal contracts are enforceable, especially when not enforcing the contract is ridiculous. You can't unwind the movie that's already been made. She's not going to be forced to give back all the money that she made. They're not going to undo what has already been done. It's too late. It's too late. Look, you wanted to proceed without her signing the contract. You guys went through this whole thing. You guys have a contract now. You got things that you can enforce against each other. It does not move the needle for me one bit. The only thing to me that is going to be unclear and that I think we need to ferret out in discovery and perhaps at trial is what were the terms of what is going to have to be the constructed enforceable contract that the courts are going to have to find. That's the big question to me. But thanks for the 5. I didn't mean to curse at you, cat lady. It wasn't you. I was just on a roll. My apologies. Amy Les with the 5 says, Omar, what happens to Blake Lively New York Times lawsuits if Jones Works text subpoena prove to be fake? Will these lawsuits proceed or be dismissed? Well, I think that's if the Jones Works text end up being fake, I think that they got bigger problems. I don't think that Justin Baldoni has any intent of dismissing the claims or the lawsuit of Blake Lively. I just don't. I think that they want to litigate this thing all the way to trial. I think that they want to put her on cross-examination. I think before they even move to dismiss anything, I think really what I think they're going to do is they want to depose her. They want to depose her and they want to beat her up on deposition. I don't think that they're moving to dismiss anything until they get that opportunity. But if there's text messages back and forth, not just with Jones Works, but with any of it, because look, we got 2 sets of PR campaigns here. There's people on both sides that have said a lot of crazy things and perhaps weird context. I don't know if it amounts to malicious intent or not, but we got 2 competing PR campaigns that were talking a lot of shit. And there's a lot of allegations. If somebody is found to have fabricated text messages, it's going to be a lot worse. The punitive damages that will be awarded, he's asking for $400 million. I know he's going to be capped by whatever, but he's going to get whatever the max is. I could imagine. I could see that. But just in the short of it, I do not see the existence, at least from Baldoni's side, of any fabricated text messages causing this case to be dismissed anytime soon. We're going through depositions. We're going to litigate this thing to the point where they're going to force Lively to answer some uncomfortable questions. And until that happens, we ain't talking settlement. We're not talking dismissals. We're not even moving for dismissals. We're not even moving for, they may move for a summary judgment. I don't know, but we'll see. We'll see. Aquanetta with the 5 says, thank you, Omar, for taking time to break down 47.1. So appreciate it. Well, it is my pleasure. It is my pleasure. I saw people freaking out about it on Friday. Like, people are asking me about 47.1. It's like, what are you guys even on about? I hadn't at that time. I hadn't even read Lively's 12B6 motion. I didn't know that she raised it as a complaint. And I admit, I mean, on first read, it's a striking thing to read. It's a scary thing to read until you just really start putting it into practice and looking at how the cases handle malicious intent, how the courts handle tolling of the statutes, and then you realize, oh, well, statute of limitations can't apply here. How are they supposed to know that she had malicious intent when she's continuing to film the movie? And then, all the other stuff that I said, not to rehash anything. David Etta Doe says, with the 7th, thank you so much. Can you please explain if the 17-point listed under her company applies to the new law? Do you mean her 17-point letter that was distributed at that meeting? I don't know what you mean by that question. Somebody help me out. What are you really asking? To the extent that you're asking me of whether or not that 17-point letter, love letter to the production team applies to this new law, yes, it applies to the law. Any kind of published statement, any kind of statement that you put out there in a defamatory capacity, I don't care if it's love letter or whatnot, it applies. The question is, does it protect her or not? You could view it in the context of 47.1, but you have to first answer the question. Was that 17-point letter maliciously drafted? They didn't know it at the time, but it might have been. Was it recklessly drafted? That's a harder thing to prove because, like I was saying from the very beginning, it's going to be an issue how much they would acquiesce to Blake Lively whenever she would say anything or disagree with them. Oh, you're such a genius. Oh, you're so this. You're such a great actress. You're such, whatever. I knew that they were going to do this. They were going to argue, look, they were so unhappy with Blake Lively that they called her a genius. And they were regularly giving her compliments. They were regularly doing this. How was she supposed to know that what she was doing was out? That's what they're going to say. They're going to go with that. And so that's what I mean. If you look at it from the lens of a conspiracy, it makes sense that people are going to be confused because, okay, this 17-point letter, that's all cool and all, but I thought that we were cool. Like we've been cool for months. What is this all about all of a sudden? It just comes out of left field. That's kind of how conspiracies are. You take this bizarre new reality and apply it to the reality that you understand, and it doesn't make sense. That's usually a red flag that something nefarious is afoot. And so, yes, I think that you want 47.1 to apply to that 17-point letter under her company. I think you want it to. They're certainly admitting that if there were defamatory statements, they were contained within that 17-point letter. But it doesn't protect anything if you could prove maliciousness. And I think if you just look at the cases, it has been a long-standing defense to defamation that people who have maliciously brought defamatory statements to smear others have done so for monetary or some kind of a gain. And for Lively, it's not hard to find motive for that. And it's less hard to find evidence of her getting rid of Baldoni, like in stages. Those are tribal issues. I don't believe that 47.1 is going to get this dismissed. Here's where 47.1 might come into play. It might survive all the way up into trial where they just leave it up to the jury. If you don't believe that the statements were malicious, then by rule, by California law, as stipulated by the parties, then you shall dismiss that cause of action as it relates to Blake Lively. They might say something like that, but they will leave it up to the the jury to decide. Tribal issue, figure out a trial, put on your evidence, we'll put on ours, we'll see where the truth leads us. That's it. That's it. And that's all. I swear to God, I thought it was more than 17. In my head, I feel like it was like 27 at one point. At first it was 17 and then it was 27. I mean, I haven't read that complaint in a long time. I just feel like there was two lists. I don't know what I'm thinking about. I hope that answers your question, by the way. Folks, I've been going for an hour. I've talked for a total of 2 hours today on this 47.1 issue. I hope for those of you that were worried that this was somehow going to give Blake Lively a mechanism to get out of jail free on the context of some woke law in California. Do not fret over that, because I thought that the claims from the very beginning have relied on the maliciousness of her intent. And now we're just putting a statute to the cause, which is 47.1 specifically says that, so we get there. I don't think that really anything has changed. Motion to dismiss is not getting granted. At best, it's going to be leave to amend, and we'll see how that goes with that. Folks, that's all I got for you tonight. I love you all. Be safe out there, and I will see you guys tomorrow for some other stuff. Have a good night, and bye-bye.